Hello, everyone, and welcome to Verdictum. Today, in our In Conversation series, we have with us Advocate C.K. Saji Narayanan. A heartiest welcome, sir. Sir is a prominent leader and the former national president of the Bharatiya Mazdoor Sangh, one of India's largest trade union. Sir has practiced in the Kerala High Court and has championed the trade union movement in the state. He has represented the BMS and the Indian labour designation at international forums, including the International Labour Organization and BRICS trade union meetings. Sir is known for his insight into labour dynamics and consistently advocating for the welfare of workers, including unorganized and migrant labourers. Sir has been a member of the Second National Commission of Labour appointed by Prime Minister Atal Bihari Vajpayee. So we welcome you on board, and today we will be discussing on the new Labour Codes 2025.
Good morning to all.
To the audiences, the 4 new Labour Codes has been introduced by the central government, which are the Code on Wages 2019, Industrial Relations Code 2020, Code on Social Security 2020, Occupational Safety, Health and Working Conditions Code 2020. These are the 4 codes which we will have a discussion about with Mr. C.K. Saji Narayanan. So, sir, let's begin by explaining to the viewers what the new Labour Code actually does. So, what changes they have made to the present regime?
At the inception, I would like to thank you for having me in this interview, especially on a very important subject that is widely discussed today in the not only in labor sector, in every walk of life, national life. And we can say by the legislation of these labor codes, and now they were notified, and we are at the threshold of a very profound transformation in the entire labor landscape. So we have to look at these codes in a historical perspective. That is very much required. Now these reforms have come up after 70 years. We can say that the labor reforms in India was initiated by Dr. Ambedkar when he was inducted into the Viceroy's Council in 1942. And in the beginning, he initiated a tripartite culture in which all labor matters will be discussed by the 3 partners together. Till that day, that was not there in the national scenario. Thereafter, he one by one formulated most of the basic labor laws in the country, even though some of them were legislated after his tenure. This includes Industrial Disputes Act, ESI, EPR, and some welfare schemes in the coal sector. Many such laws were formulated by Dr. Ambedkar himself. So after a span of about 78 years, now we are having a new regime of labor laws. We can say that it is legislated following the recommendations of the Second National Commission on Labor. And our organization BMS has termed it as 2 codes as historic and revolutionary. The 2 codes are Code on Wages and Code on Social Security, because it brings total change in the labor sector in the country. So there are it's a very comprehensive codes consisting of the 4 codes totals about 480 sections. It's a very large legislation. From the perspective of the workers, I would like to say that there are about 9 to 10 basic changes in the labor codes. I will just mention one by one and I'll elaborate later. One is universalization of minimum wages. This is happening in the country. Second is social security and occupational safety and health. These are partially universalized. So this is happening after a span of about 78 years, and this universalization process, we can say, this historical revolutionary as far as our working workforce is concerned, because we have got one of the largest working population in the world, nearly 50 to 55 crores or 550 million people are in the working sector. Second is the gender discrimination is addressed in a wider way in this code. Previously, we had the Equal Remuneration Act, but that has been widened, and in some more areas, this gender discrimination has been addressed. Another thing is considering the vast working population, the labor machinery, the labor department is very, very small. The strength of the labor department is very small. So that also has been to a certain extent addressed by this code. Then several legal procedures have been simplified in this code. For example, the industrial tribunal, now there is only one industrial tribunal. There is no reference. The judgment copy is directly given to the parties, etc. These are all simplification of the legal procedures. Then we don't have a legal procedure for verification and recognition of trade unions. For the first time, such provisions have been made in the labor codes. Another two important things are the labor has got an identity. Today we have a lot of informal work arrangements. They are all formalized by insisting that an appointment letter has to be given to every worker. So that means the work relations are formalized. Then compulsory health checkup to every worker once in a year. That also is a big step. Then considering the big population, working population in the country, how to enroll them, how to carry the benefits to the last worker in the country. This is a big issue. For that purpose, this labor code envisages worker facilitation center at the lower level. At the beginning, it will be at the district center, but later it will be this for all the local bodies, panchayats, corporation, etc. That will be they will have to take up the responsibility at the worker facilitation center. Then protection is extended to unorganized sector. There are about 12 benefits given to the unorganized sector. This is also a very, very good step. Then overall, we can say because of the universalization of minimum wages, taking it to the last person in the country, last worker in the country. Now it will have a great impact on the economic transformation of the country. So these are some of the layering aspects in the labor. Next.
So, sir has given a comprehensive view of the codes. So, sir, my next question to you would be, how do you see the code strike a balance between the interest of employees and employers?
Now, striking a balance between the interest of employer, worker, as also the interest of the society. These three has to be taken care of. In 2015, when the labor codes were being in the drafting stage, there was a lot of confusion, discussion, etc. at the national level. At that time, a Indian labor conference was convened by the government. It was in 2015. In that, there was a committee on labor reforms. It was a very controversial thing at that time, and a lot of discussion took place. And finally, all the three partners together, the trade unions, the employer organization, and the government, state government, and central government representative, they came together and said that there are three objectives for labor reforms, labor legislation. The one is industrial peace. Second is labor welfare. And third is industrial progress. All the three things have to be taken care of by any legislation. So to an extent, labor codes have taken care of these three aspects. So even at the floor level also, the labor code has tried to bring a balance by giving a separate chapter is there, bipartite forums. The management and worker has to sit together and sort out all the issues related to them. At present, what is happening is the worker, if they got any grievance, he has to rush to the labor department and complain. That system has been now done away with. Directly, they can sit together and sort out. If the bipartite mechanism fails, then the tripartite mechanism can be resorted to. So these are all bringing a new work culture, new type of culture in the industry scenario. Next question.
Yes, sir, please. Sir, with all the four codes that has been introduced has in their heart the issue of meeting the demands of the workforce, which has been raised over the decades. So, in your view, do the new labor codes meet the major demands of the workers, which have been raised over the last decade?
Yes. For the last several decades, the trade unions, the employer organizers, everybody was demanding for overhauling the labor legislation, because for decades it is remaining without any change. So there should be reformed. It should be reformed in favor of the workers. And another thing is India has got a plethora of labor laws. At the central level, there are 44 labor laws.
Yes, sir.
And at the state level, there are hundreds of labor laws. So all these things have to be codified into a and simplification of procedure also is required. These were the demands raised by the trade unions. These demands were raised before the second National Commission also. So the second National Commission also very strongly demanded that the labor laws should be reformed, they should be simplified, and they should be codified. And it also should address the shortcomings in the existing labor laws. So these things have been, these concerns have been mostly addressed by the new labor.
Okay, sir. So you mentioned simplification. So we can delve on the aim of the new labor codes, which is said to be simplification, security, and sustainability. So how do you see they sail with that?
Now, our labor laws, actually, they were drafted during the British colonial period or at the end of the colonial period. So it's all based on the Anglo-Saxon system. So a lot of such things are there still remaining in the labor laws. For example, suppose there is a conciliation fails, it has to be referred to the government. The government will refer it to the concerned labor court or industrial tribunal. This takes a long process. Sometimes it takes 2-3 years to reach the court. Another thing, even if the court gives a verdict, that has to be published in the Gazette. These are all unnecessary things. Nothing, even the civil court or other courts, we don't find any such thing. So these are all relics of the colonial era. So these should be removed. So such lot of such procedures, complications are there in every labor law. So all these things have been consolidated together. But another thing is in the wage. There are several wage laws in the country. They also have different procedures. So all these are consolidated together right now. And we have similarly social security, OSH, etc. All the laws have been consolidated. Common procedure has been prescribed for them. Next.
Yes, sir. So ultimately, the laws should be in favor of the beneficiaries. So how could you list the positives from the codes which you see as a win for the workers across the country?
We can take the codes one by one. Let us discuss about the wage code. Now, when India became independent, everybody expected that the living standard of the people should rise through proper wages. So the government appointed a committee. It is called Fair Wages Committee. And the Fair Wages Committee submitted its report in 1948. It said that progressively the wage level of the worker should be raised from one phase to another in a particular span of period. The first stage will be minimum wages should be ensured to all. From there, it has to raise to the fair wages level, and from there, it has to raise to the living wages level. This is the thing. But even after 78 years, today we are discussing about how minimum wages can be implemented to the workers. So today only 7 to 10% of the total working force has minimum wages. This is a tragic situation. So this labor code brings a drastic changes in the perception, and now the last worker himself is empowered with the minimum wages. This is a big achievement. Previously, in the minimum wages law, there is a scheduled, and only those sectors listed in the schedule will be covered. Now that scheduled system is totally removed. Even in different sectors have different wages, and even in one sector, for different categories have different wages. So these are all things. Now this code attempts to make a uniform pattern for all these things. Another thing is revision of wages is made compulsory in every 5 years. So that is also a good thing. Regarding gender discrimination, also wage code makes some provisions. Today there is a provision for equal remuneration. Apart from equal remuneration, this code envisages that there should be equality in recruitment procedures. Men and women should have equal opportunity for recruitment. Another thing is in working condition also, there should be equality. So that discrimination is removed in all the three aspects. Now, the payment of wages is made compulsory through banks. That's also
Okay.
another big issue that came up before the uh, government while making universal minimum wages was how to implement these things.
Mhm.
So from the inception, myself and my colleagues were involved in the process of discussion and consultation with the government. This issue came up. Then we suggested there are in some European countries there is a practice of empowering the worker to a legal right to claim wages. Today in India, if you want to file a criminal complaint for not getting minimum wages, you have to approach the inspector. The inspector will go there and he will take money and he will not do it. So these problems are there. So we demanded that the present right to file criminal complaint that is vested in the labor inspector, that should be given to the worker as well as the trade union. Finally, that was accepted, and now the labor code contains a provision where the worker can directly approach the. So a worker in the remote village who doesn't get minimum wages, he can directly approach the nearest criminal court and he can file a complaint. This is a sort of empowering the worker, and the question of implementation also will be uh, addressed by this thing. Another thing is you have to file a claim for wages within 6 months.
Mhm.
That period has been enhanced to 3 years. So these are some of the takeaways in the uh, code on wages.
Mhm. Yes, sir. So now that we have a broad view about the codes, let's magnify a bit. And I would like to ask you that the rules allow for longer factory shifts, night work for women, and raises the threshold for the firms that need prior approval for layoffs from 300 to now 100. So what are your thoughts on that?
Uh, Now regarding these two things, uh, uh, regarding shift, etc., there is a lot of controversy regarding the working hours. Now, the code has made an advancement. Even in the Factories Act that is currently we use, there the working hours is 9 hours. In the code, that has been reduced to 8 hours, and only the spread hour is up to 12 hours. So the working hours has been now settled throughout the country as 8 hours per day. But if they are taking shift, etc., they can have that will be spread over. But consequently, they will be getting a compensatory holiday on the next day. So that is also has been taken care of. Another thing is regarding the night shift of women workers.
Mhm.
Women workers are given the right of night shift because of the demand of some of the NGOs. They came to the court and court said that women also should be allowed to work in the night shift. But the court has made some observation that there's security, their traveling, etc. Because in Indian circumstances, you cannot adopt the European system because many of the factories are situated in remote places.
Yes, sir.
So women traveling, etc., that problem is there. So
Mhm.
the court take care of security, their transportation and other facilities should be provided. And the consent of the concerned worker also, women worker also is required. With these provisions, night shift is permitted for women workers.
So, picking up from the controversy, as you mentioned, and the criticism, so I would like to bring you the point that provisions linked to the closure of factories, right to strike, and easing of the compliance burden for smaller units, these issues have received a heat from the labor unions only. So, how do you see that?
Now, uh, there are still issues remaining in these codes. We have said the wage code and social security are historic and revolutionary. OSH part of the OSH and
Mhm.
WC code also is very uh, in favor of the workers. But in the IR code and the OSH code, there are some issues. We have identified about 12 such concerns in the
Okay.
IR code and 12 such concerns in the OSH code. So we have raised this before the minister. Minister said definitely we will address this concern in a short while. That has been there. The main issues now remains is basic issues are three. One is the issue of threshold, raising the threshold. Threshold has been now raised in the standing orders from 100 to 300 percentage. Another is Chapter 5B, that is retrenchment, layoff, and closure. There also threshold has been raised from 100 to 300. Then regarding contract labor also, it has been raised from 20 to 50. Similarly, Factories Act, it has been raised from 10 to 20 and 20 to 40. That way, it has been enhanced. Then for some other sectors like newspaper employees, then transport sector, etc. Also, there this has been doubled. So this enhancing the threshold is a basic issue which we have raised before the that will uh, take the workers a considerable portion of the working population outside the purview of laws. So we have raised that issue for the minister, and minister said he will be considering it. Another is
Great.
restrict on the activities of trade unions and their right to strike. This is also an issue we have raised.
Okay.
Another is the exemption regime. There are two types. There are explicit exemption provisions in the code. Another thing is the government is given power to exempt units, factories, sectors, etc. from the purview uh, of the Act. So these are all some of the basic issues concerning the labor code which we have raised before the uh, labor minister. He said he will address those issues.
Yes, sir. So you have also been a major voice for the marginalized. So, how do you think the Occupational Safety, Health and Working Condition Code 2020 does it amply cater to the unorganized sector for they continue to be the major part of the workforce?
Yes. The OSH code has two parts. One is occupational safety and health part. Another is working condition part. Now, OSH part, when we look at the OSH culture that exists today, there are four laws which deals with occupational safety and health, and there are another three laws which partially covers the OSH aspects. the entire all the other sectors are outside the law of any protection of occupational safety and health. By this OSH code, any unit having more than 10 workers, now they are covered by the OSH and safety, occupational safety and health provisions. Then the employees have got a right to get information. What are the protections the management has taken regarding occupational safety and health in that particular unit? If the management doesn't give provisions, then he has the right to complain to the inspector. These two rights have been given. Another thing is the right to the remote village where more than 10 workers are working in a unit. All these are covered by the occupational safety and health provisions.
Yes, sir. Sir, since we are on the topic of unorganized workers, so the new codes provide for minimum wages to the organized worker. How much difference do you see it will be making in the lives of these workers who have always been at the whims of their employers?
Now, the minimum wages act as it stands today, it applies only 7 to 10% of the total working force.
Mhm.
The rural areas, the villages are all outside purview, and the worker working in the villages, they don't have a reach to all these legal provisions. But enacting the code on wages now that has been implemented to the last worker in that country. That will have a very tremendous impact on the economy of the nation. Because once you ensure minimum wage to the last worker in the country, his purchasing power will increase. So the average purchasing power of the citizens of the country will increase. That will vitalize the market. And when market is vitalized, then normally that will the manufacturing activities will increase. And manufacturing activity also increase. They will be able to pay more to the workers. Remuneration. This will act as a virtuous cycle. Yes, as an economic cycle. So ensuring minimum wage for the last worker in the country, especially at the village level, rural people, etc. That will definitely bring a transformation in the economic landscape of the country.
Yes, sir. So, over the last years, we have seen that the platform and gig workers' growth in the working force have gained tremendous strides. And with this new economy emerging, how do you see these new labor codes catering to them, since they are providing them with the social security, formal social security for the first time? Do you see it as a timely intervention with respect to now that they are a major part of the workforce?
Platform and gig workers are a new category which has developed during the last 1 or 2 decades.
Yes,
And for the last 10 or 5 to 10 years, the number of platform and gig workers in the country has increased like anything. It's a newly emerged sector. Throughout the world, governments are discussing about how to
address their
bring
issues.
some legislation these issues. And in many countries, even the question of recognizing them as workers, that issue still remains.
Yes, sir.
Probably India would be one such country which has recognized them at least partially as a worker for the sake of social security. So for gig workers, there are 6 benefit has been provided in the social security code. In that respect, India has actually advanced very much compared to many other, even some of the developed countries. India has advanced. It's a good step.
Yes, sir. Said we have discussed on the major portions of the codes and how they fit into this emerging economies and the new realities of the working conditions that we find ourselves in. So I would like to ask you, in the end, how do you find is there any issue which you think has still not been addressed
Yes.
by the codes with respect to the workers?
Yes. Now, when we look at the social security, code, there also the compulsory registration of all establishment has been made. And ESI is now applicable to every establishment which is doing hazardous work, even if one worker is working. It's a big step. For all other establishments, if they are engaging more than 10 workers, ESI will be applied. This is going to be a big step because ESI is one of the best health insurance in the whole world because it covers about 6 benefits. It also covers the family members. In that respect, it is one of the largest one. And today, because of these provisions, India is going to be having one of the largest social security system in the whole world. Similarly, EPF, Employees Pension Scheme and EDLI, these are all going to be implemented for every unit having 20 or more workers. In ESI and EPF, you will find in that act that is currently working. There is a schedule at the end. Schedule is some sectors. Only to such sectors it is applicable. So that schedule is also removed. So now every unit having more than 10 workers, ESI is applicable. Every unit in the country having more than 20 is applicable. So it's a big step towards universalization. Another important issue addressed in the ESI is that if the employer fails to enroll himself, or if the employer fails to insure the employee, then also the worker is covered by the ESI thing. So then ESI, it is the duty of the ESI office to collect the expenses from the employer. In that way, also it is there. Another thing is notional extension of workplace. That is when a worker is traveling from his house to the factory, if something happens, whether it is covered. The precedents or the judgments coming from the higher judiciary, it are always fluctuating. Sometimes it will be in favor of the worker, sometimes it is against it. That is there. That also now settled. So even when a worker is traveling from his house to the factory, he will be covered by the ESI or by the employer compensation. Now, unorganized sector also has been brought under a big social security scheme having 12 benefits. This is also historic. So that also is a big leap in this thing. Then interstate migrants, home-based workers, domestic workers, and fixed term employees. All these are now covered by different schemes in the scheme. Then principal employer is liable for the payment of contribution of the contract labor. That is also there. Then for migrant workers also, there is a unique number will be given, and once he goes from one state to another, still he will be having a portability of his benefits. Then for fixed employment, that is for 2 or 3 years. So for them, gratuity is covered even if they are having it is below 5 years. These are some of the benefits in the Social Security Code. In the OSHN working conditions, all units having more than 10 workers are now coming under the occupational safety and health provisions. It is there. Then in the Industrial Relations Code also, there are some good things. There is a conciliation officer is given the power to enforce attendance. Now onwards, the conciliation will not fail for the lack of attendance of any of the parties. So they will enforce that they will attend the dispute. Similarly, the current bifurcation of labor courts and industrial tribunals, that is also done away with, and there will be only one industrial tribunal onwards. All the labor courts will have to change their name as industrial tribunal right now. Then there is a new provision for recognition and verification Then the tribunal also is given the power to give interim relief. It's also a long pending demand of the trade unions. So these are all some of the new provisions in the labor codes.
Sir, we have reached the end of our interview, and we would like to thank you for this insight that you have provided us. And hopefully, it will help the viewers understand the new labor codes better with your simplification. Thank you, sir, for giving us your time.
Thank you very much. Thank you.
You're welcome.